kindly remain standing for a word of prayer, and I'll ask our resident pastor, Mr. Dominic Otuchet, to give us a word of prayer.
Let us humble ourselves and pray. God our Father in heaven, thank you for this special moment, this special occasion. Thank you, Lord, for our country, Uganda. Our national motto is for God and my country. And the God we are talking about is you, the God of Abraham, Isaac, and Jacob, the God of our salvation, the God of our country. I want to dedicate this program to your loving hands. Father, we know that as it is being launched today, it will roll out and the realities will also come. Lord, we thank you for the organizers. Thank you for everybody that is here and those that are coming. May your name be glorified. In Jesus Christ our Lord we pray. Amen.
Thank you very much, Mr. Dominic Otuchet. You may kindly take your seats. Ladies and gentlemen, you may realize we may have a bit of competition from outside, so we'll try and push things as fast as possible so we don't really have much of interruptions therein. I'm supposed to make a few remarks on behalf of the National Sports Arbitration Moot. However, if you have received a document before you, it will detail some of the pathway, the universities that participated, and that, of course, would have been quite obviously what I was going to make comments about. I will leave that to you to enjoy for your reading. In the house with us here today, we have university students that have taken part in the NASAM. We call it the NASAM. Other university students that have come to cheer on their teams. We have members of the press and members from different sporting federations in the country. Ladies and gentlemen, in the house, Mr. Dennis Musali from Cricket Uganda, the General Secretary. Mr. Tusime Liberty, Uganda Lacrosse Association. I hope all of you know what lacrosse is. You'll ask him after. Yes, you'll ask him after. We have Mr. Simon Peter Komakech from the Modern Pentathlon. Thank you very much. Mr. Dominic Otuchet from Uganda Athletics. The man that is producing the gold medal winners for Uganda. Yeah? Look out for the Commonwealth Games. They're coming sometime this month. This month? Next month? Yes, this month. A very strong team that they're taking to Scotland, right? Wonderful. Mr. Bernard Baineman, the CEO of the Uganda Premier League, Star Times Uganda Premier League. I believe if you've read the Moot facts, you now know where our problem comes from. Eh? Yeah? You now know. And we are very happy to have you because I think this matter is very integral to the sport of football in this country. We'll listen to how it possibly would have ended. And ladies and gentlemen, with a special recognition, Professor Celestino Obua, the chairman, National Anti-Doping Organization, Uganda. I was earlier on tipping him that, by the way, after this football moot, you can take a guess on which the next moot will be on. Anti-doping. Yeah, so go and do your homework. I can see Gubat is nodding his head. It's no significant fault, eh? All right, ladies and gentlemen, I would like to invite Mr. Timothy Kaja to speak on behalf of, he is the chairman of the Young Africa Leaders in Sport, to give us his brief remarks, and thereafter we'll dive into the serious business of what brought us here today. Mr. Timothy Kaja, please.
Thanks, Leon. And our dear guests, I'll stand on the protocol already established. And briefly about YALS, whose full name is Young African Leaders in Sport. It's good to see very young faces here. It's basically an African-wide organization working under the African Union Sports Council. And our purpose is really to nurture us and create opportunities for young people in the field of sport. And this is exactly what we are doing. And we are partnering with Mashariki, which is a local sports firm that is doing sports advisory in Uganda, to bring this home. And of course, we cannot, these people who, our unsung heroes, we cannot forget them. Mr. Leo Nsenyange, who's hiding behind there. He has worked very hard to have this come to life. Mr. Fidel Otafire, who is here with us, he has worked also very hard to have this come to life. And of course, I would like to thank all the universities that participated, from the earlier rounds to those that have made it thus far. And of course, we apologize that even this should have been come up earlier. But when you're starting something new, there are challenges that come your way that you don't foresee. But what matters most is at the end of the day, we get it done. And all of you that are here, we are doing this for the first time. So you're the first timers. There is no one who has done it before you. And it will be incumbent on us to ask us how you did it to get this far, because no one has gone above you. And we welcome you to the world of sport. We are privileged to have the administrators that are here. And earlier, our seniors, when they were looking for whose land to sell next, who to grant bail or something, now that field is overpopulated. Now these are the people you should ask. If you have the chairman of the National Doping Committee, it's your time to engage. Those are the new contacts. We're not going to do what our seniors did decades back. This new space that hasn't been cultivated before. These fields are really filled with the best yields, and those yields are yet to come to life. So engaging in this is taking part in cultivating this field, in the field of sport. This is a multi-billion-dollar industry that we are yet to get the best from. The World Cup is happening currently. FIFA is making at least $13 billion from only one tournament. And guess what? Next year we also have the chance to host a tournament here. It will be the first. And that's what I'm saying. You're in a line of firsts. That means there's plenty of opportunity. After that, we have the African Games. That will be also a first. So you want by the time those firsts come to life, there's not only opportunity for you to engage, but you've also had the chance to build those. What we are doing is what is going to affect us. When you look at games in the AFCON, the African Games, they have ad hoc dispute resolution tribunals. So who's going to sit on those? Are they going to fly in someone from Mexico when you're here? Make that a no by doing what we are doing now, knowing that we are not only doing it for ourselves, but we are building something that has never been put up before. And we are not only having the chance to participate in this, in the building of this industry, but also to shape it. An opportunity that you may not be able to get in other fields of practice that have already been really modeled by the seniors that went before us. So those are my few words, and I invite all of us to enjoy this session and learn from each other. Like I said, because it's a first, we are all learning. So there is no pressure. We are all learning. We are building the Ugandan sports economy. We are contributing to the global sports economy. Thank you very much.
Thank you very much, Mr. Timothy Kaja. Now, for those of you that love rugby, there's what we call malaria time. Yeah, you know malaria time. You people should be watching sports, eh? Malaria time. Yeah, that's when you look back at a final between the Pirates and Buffaloes, and the final score is 30-29, and Buffaloes is in the charge in the 22 of Pirates with a chance to win the malaria time. So, ladies and gentlemen, we'll jump straight into the matter that has brought us here today. I'm going to ask that you give us 5 minutes just to do a quick setup, putting up the tags. Then we'll do the official announcements and invite our arbitrators and our participants to take their seats so we can have this session starting proper. Right? Wonderful. Thank you very much. right. Ladies and gentlemen, we are about to start. I believe all of you have read the case detail. Yes, you have read the case detail. An intriguing case that we have before us, an issue of match manipulation and the eligibility of a player. One element of this particular moot problem comes specifically from a real event that happened in the Uganda Premier League. Mr. Bibi is very keen on that. So we decided to have this matter that actually went to CAS. As a matter of fact, it went to CAS and was withdrawn. And we thought ourselves, which better case to start with than a CAS case? It's not the first case from Uganda to go to CAS. We've had a couple of others, about 2 or 3. More recently, one being decided, Vipers against a foreign coach. But nonetheless, we are having the opportunity now to discuss something that has been within our proper space. Ladies and gentlemen, I would like to invite you to the inaugural National Sports Arbitration Moot 2025-2026. And let me hear a bit more of that. Thank you very much. Thank you very much. The matter before you is a matter of Kakyanga FC versus the Football Association of Zamunda and Mpalaka FC. Representing the appellants, Kakyanga FC, ladies and gentlemen, put your hands together, for Cavendish University, Nabagala Jovia and Maweji Alvin, representing the respondents, the FA of Zamunda and Mpalaka County FC, Mr. Gilbert Musoke and Owundo Edward, the respondents, from Makerere University. And to arbitrate this matter, ladies and gentlemen, let us welcome Mr. Timothy Kaja from the Young African Leaders in Sport. Mr. Timothy Kaja. He is also the first Ugandan to win a case at the FIFA DC, right? First Ugandan to win a case, and also one at CAS. A man that has been through the sports field quite well, and indeed continues to preach the gospel of sports, dispute resolution, and sports law. Ladies and gentlemen, our second arbitrator for the day, Ms. Lakay Leslie from the National Council of Sports Legal Department. Thank you very much. For the sports federations that are here, I believe you have been through her office. Yes, you have been through her office. She's responsible for the compliance of sports federations in this country. Busy weeks it's been for Leslie Lakay and the legal office. Ladies and gentlemen, welcoming the president of the arbitration panel here today, Mr. Fidel Mugara Otafire, the founder of Mashariki Sports and Entertainment Advisory. A graduate of East Day, Spain, with the Global Masters in International Sports Law, has been through a couple of cases locally here and internationally as well. I think in South America as well. South America and England. So yes, we have a very formidable arbitration panel. And to help us, ladies and gentlemen, with the business at the front, the clerk, Louis Guochalia, she'll help us with the timing and also the guidance with this session here this morning. Ladies and gentlemen, allow me now that we have set our session, allow me hand over officially to the president of the panel.
Good morning, ladies and gentlemen. Thank you once again for your attendance. If we may proceed so we can save time. The hearing of the National Sports Arbitration Moot is now sitting as a simulated court of arbitration for sports is now in session. This session will be held before a 3-member arbitration panel, which shall be introduced to you shortly. Although we are in a simulated hearing, it is expected that we are respectful in our conduct, professional in our etiquette, and we are working in good faith. Allow me to now introduce the panel. I shall introduce myself as the president of the panel. I'm Motafire Fidel, and I'll allow my fellow panel members to introduce themselves.
Good morning. I am Leslie Lake Okot, and I'm also a panelist. Glad to meet you.
Good morning once again, Timothy Kaja, and I'm a member of the panel.
Thank you. Once again, I would like to thank both parties present for their written submissions and for honoring the court summons, the arbitration summons. And I do take this opportunity to request them to confirm their appearance and whom they are representing. Thank you.
Greetings, honorable members of the panel. My name is Nagala Jovia Ann, and I do represent the appellant, in this case, Kakyanga Football Club.
Thank you, honorable members of the panel. My name is Councillor Maojo Alvin, and representing the appellant, Kakyanga FC, in this matter.
Good morning, esteemed arbitrators. My name is Msoke Gilbert, and I'm lead counsel for the respondents, Football Association of Zamunda. Thank you.
Thank you. Thank you so much. Thank you so much for this opportunity, dear members of the panel. My name is Edward Oundo, counsel for the respondents in this matter, Football Association of Zamunda and Mpalaka County FC. Thank you.
Thank you very much to both parties. I would like to take this opportunity to once again remind you of your time constraints. Each side will be given 25 minutes for their submission, and they'll also be followed by 5 minutes for a rebuttal. As you have been informed in the briefing, there will be certain leeway to allow you to finish your submissions. However, we do ask you respect the timing, not to prejudice the other parties. We'd also like to remind you that there may be moments when the panel may interrupt your submission to ask questions. That too will be taken into consideration with your timing. With all that handled, I believe we may begin this session. But before we begin, are there any preliminary objections?
Thank you, Mr. Arbitrator. Indeed, we have a preliminary objection in regards to the jurisdiction of this tribunal to entertain this matter.
Please do elaborate.
We acknowledge that CAS ordinarily has jurisdiction to entertain decisions arising from final decisions by member associations pursuant to Article R47 and Article 57 of the FIFA statute. But then certain conditions were not fulfilled that are pertinent to the integrity of sports. And so we request to first submit on jurisdiction before we go to the merits of this case.
Yes, you may submit briefly, under 2 minutes.
Thank you so much for granting us time to address the preliminary objection. Good morning, honorable arbitrators, once again. My name is Msoke Gilbert, appearing on behalf of Zamunda, appearing on behalf of the Football Association of Zamunda. This case asks a fundamental question. Can a national football association acting diligently within its own domestic framework render a final decision on a purely local matter, or must every such decision be reopened before an international tribunal simply because one club wishes it so? We submit with respect that the answer is clear. This panel does not have jurisdiction and the appeal should be dismissed immediately on this preliminary ground. We intend to challenge the jurisdiction of this panel on 2 major grounds. First is that the lower body is correctly reached a final decision in regards to the decisions rendered in Zamunda. The evidence under paragraph 18 and paragraph 19 shows that on 16th April 2025, the FAS adjudicatory chamber and disciplinary panel issued their decisions, and Kakyanga FC appealed on 18th April via paragraph 20 of the facts. And on 24th April 2025, the FAS Appeals Committee rendered its decision after carefully reviewing all the evidence and upheld the sanctions expressly, declaring them final under Article 55 of the FAS Ethics and Disciplinary Code, that is under paragraph 21 of the fact sheets. Article 55 is unequivocal. It states that the decisions of the Appeals Committee is final and binding. The lower bodies acted with procedural fairness and reached a conclusive national determination, and all internal remedies were exhausted, and that should end this matter. Would like to also persuade this tribunal to consider the policy considerations regarding party autonomy in regards to allowing domestic bodies to handle purely domestic disciplinary matters, just like this one, without interference, because we do not see any international aspect applying in this particular matter, just like it was in the case of Royal AM Football Club versus South African Football Association, CAS Arbitral Award 8403, a decision rendered in 2021, where in that case, the Honorable President of the panel at that time observed that there can be no arbitration without consent expressed in an arbitration agreement, and that the FIFA statutes do not contain any mandatory provision that obliges a national federation or a league to allow a right of appeal from its decisions. And as a result, no right of appeal of the CAS exists until the national federation or the league has made provision for this right in its statutes or regulations. And that takes me to consider the discourse that was considered in this particular case, where they said that Article 57 is merely directional and it's not a mandatory clause.
Sorry to interrupt you. One, to remind you your time constraints, and then two, also to give you a heads up that there will be an opportunity to discuss this further. We just ask for a quick summary. Otherwise, we will now enter into pleadings.
Okay. Thank you so much.
If the appellants have any quick.
Thank you so much, honorable members of the panel. I would like to submit or to respond to the respondent's preliminary objection to this court's jurisdiction by stating that the respondent's argument cannot stand before this court, as their main basis of argument is that there is no arbitration agreement, or there is no arbitration agreement by the Football Association of Zamunda, which clearly stipulates for the Court of Arbitration for Sport. Members of the panel, Article 87 of the FAS Ethics and Disciplinary Code clearly and expressly provides for this court. If I may proceed verbatim, it provides that decisions taken by the Appeals Committee are final, as the respondent actually stated, but they are subject to appeals with the Court of Arbitration for Sport. Therefore, it is the appellant's submission that this court indeed has a jurisdiction to hear this matter. Thank you.
if I understand, you're saying that if allowing the CAS to intervene will be taking away the opportunity of the local arbitration tribunals to do their work?
Thank you for that question, Mr. Arbitrator. Our point is that in instances where disputes arising are of a disciplinary nature and involve domestic aspects which are not having international aspects, just like Article 57 of the FIFA statute envisions, then CAS should not exercise its oversight powers over these domestic associations.
You're quoting the FIFA statutes.
I quote the FIFA statutes read together with Article R47 of the CAS Code.
What about the rules of Zamunda, the Football Association?
Thank you. The rules of the association under Article 86.12 of the FAS Ethics and Disciplinary Code, there is a condition of precedent in that it provides that the decisions of the appeals committee may be appealed to CAS provided that the procedural requirements in the FAS statutes are complied with. And in this case, the procedural requirements have not been established yet in regards to handling appeals of a disciplinary domestic nature.
But summarily, 87 allows an appeal.
Summary 87 allows an appeal when read together, provided that the conditions under Article 86.12 are put in place. And one of the conditions is that there is no independent arbitration agreement that speaks to the consent of FAS being bound by the decisions or like being bound by CAS's jurisdiction.
What about 87? Does it put any conditions?
87 should not be read in exclusion of Article 86.12, which speaks to it.
But my question is, 87, does it put any condition?
It doesn't put any condition.
So you agree that they are in line to appeal unconditional under 87?
There is no such thing as mandatory right of appeal as established in the case of Royal AM Football Club versus South African Football Association at page 8, at paragraph 86, where the president of that tribunal at the time observed that mandatory arbitration can only be valid in the event that the CAS is properly constituted and the matter is properly before it. Thank you.
Thank you very much for your submissions. If you may allow the panel just a minute to harmonize, and then we'll get back to you. Thank you.
All right, thank you. So our finding is that Article 87 of the Zamunda statutes is unconditional. So the preliminary objection is dismissed and we'll proceed with the full hearing. Thank you.
Thank you very much. Again, to save time, we invite the appellants.
Members of the panel, thank you so much for this opportunity. As earlier stated, my name is Nawagala Jovia Ann, and I appear on behalf of the appellant, the Kakyanga Football Club. In this matter, I appear with my co-counsel, Maweje Alvin. Members of the panel, with the permission of the presiding arbitrator, I beg to address this court on issue 1. Thank you so much. Members of the panel, Issue 1 deals with the jurisdiction of the Court of Arbitration for Sport. And I would like to first bring to the notice of this panel that Kakyanga Football Club is not merely before this court because it is opposing a sanction, but rather the fact that it is defending its name. The allegations in which this club is being pertained to are very serious. Members of the panel, a club's reputation is built over a course of very many years, and that reputation can be tarnished the moment a stroke of manipulation is added to its name, leaving behind a stain that not even football can wash away. Which is why I would like this panel to point to the actions done by the club and not what others later on assumed those actions meant. Proceeding to issue 1. Issue 1 deals with the jurisdiction of the Court of Arbitration for Sport. And the Court of Arbitration for Sport derives its jurisdiction from Article R47 of the CAS Code, read together with Article 57 of the FIFA Statutes. Article R47 lays two foundational conditions, and that is the fact that the regulations of the said body must have statutory basis for CAS, and two, that the local remedies must be exhausted. It is very clear, as I stipulated before, that Article 87 indeed provides for CAS's jurisdiction. And the appellant, if I may refer this panel to the facts on page 3, paragraphs 18, 19, and 20. Paragraphs 18 and 19. Is the panel with me? Paragraphs 18 and 19 show that Kakyanga Football Club was indeed sanctioned by the FAS Adjudicatory Chamber. Paragraph 19 clearly portrays that the same club was sanctioned by the FAS Disciplinary Panel. Paragraph 20 then portrays the fact that this club appealed to the Appeals Committee. The Appeals Committee is the final appellate body in Zamunda. This sequence is important as it shows the clear exhaustion of local remedies. Proceeding to Article 57 of the FIFA Statutes, Article 57 is a statutory basis for CAS's jurisdiction and does provide for two requirements. The first requirement being the fact that the body or football association must be a recognized FIFA member association, and two, that the appeal must be filed within 21 days. Paragraph 1 of the facts on page 1 clearly show that FAS is a recognized FIFA member association. And if I may refer this panel yet again to the facts, and that is in regard to the fact that this club filed the appeal within the 21-day timeline. Paragraph 21 of the facts, that is on page 3, clearly shows that the club received notification of this challenge decision on the 24th of April 2025. Paragraph 23 then shows that the club filed its appeal on the 8th of May 2025. That is well within the 21-day timeline, clearly stipulated under Article 58. Accordingly, the respondent does submit and prays that this court may find that it has jurisdiction to hear the matter. I'll now move to submit to this court on issue 2, which deals with whether there was violation of the FAS Ethics and Disciplinary Code in regard to match manipulation. It is the appellant's submission that there was no such violation, and I will demonstrate that with 3 limbs of argument. First, that there is no direct link connecting the club, Kakyanga Football Club, to the alleged match manipulation. 2, that the Terrazzo Sports Integrity Report alone is not enough to prove to the proper standard of proof in match manipulation cases. And 3, that the facts at hand do not fall within Article 43. Proceeding to my first limb of argument, which is the fact that there is no direct link connecting Kakyanga Football Club to the alleged manipulation. If I may refer this court to the case of Oleg Peskovic versus the Latvian Football Federation, Case Award 5338 of 2017. In that case, it was clearly stipulated that it is not enough to show alleged manipulation, but rather there has to be an evidentiary link connecting the club to the alleged manipulation. In the facts, that is on page 2, paragraph 9, the only connection the respondent has that connects the club to the alleged manipulation is the fact that the club's officials and head coach at a football ceremony actually was seen having a chat with Chuck Mugweri, a prominent referee in Zamunda, as well as Yuri Zacharia, the CEO of Leobet. That was an award ceremony, a public one for that matter. And the respondent does not in any way provide any evidence before this court that anything that happened at the ceremony was suspicious. that is clearly bringing the fact to the matter at hand that there is no evidentiary link that establishes or that in any way puts the club, Kakyanga Football Club, in cause of the alleged match manipulation. Proceeding to my second line of argument, which is in regard to the fact that the Terrazzo Sports Integrity Report is not enough to prove to the standard of proof for match manipulation cases. The standard of proof in cases of match manipulation is the comfortable satisfaction of the adjudicatory panel, and that is clearly stated under Article 66 of the FAS Ethics and Disciplinary Code. The case award of Besiktas JK versus UEFA clearly explained comfortable satisfaction as being more than a mere balance of probabilities, but less than proof beyond reasonable doubt. Members of the panel, the respondent is simply relying on one single report, which report does not even have corroboration to establish that this club was actually involved in match manipulation. Members of the panel, if I may point this panel to the case of Kulubi Sportives Skandavu versus UEFA, case award of 2017. In that case, it was stated that the facts must not be in isolation, but rather they must be cumulative so as to establish a pattern. Members of the panel, the respondent is simply relying on a single report. There is no pattern that can actually establish any alleged manipulation. And if I may contrast the facts of that case to the case at hand, in the Kulubi Sportives Skandavu versus UEFA case, UEFA had a span of 50 matches. They had reports from 50 matches to show that the club actually was involved in match manipulation. In the facts at hand, there is simply one single match, no other, in which the appellant was involved in, and the respondent claims that match manipulation was actually corroborated by one single report in one single match. Moving on, under paragraph 86 of that same case, it was stated that betting evidence must be corroborated. The betting evidence at hand is not corroborated. The respondents do not have any corroboration for that betting evidence. They are simply relying on the one report from Terrazzo Sports Integrity Services and the Football Association of Zamunda's investigatory channel, still on that same report. Further, under paragraph 87 of the Kulubi Sportives Skandavu versus UEFA case, it was stated that there has to be correlation between the sports betting analytics as well as the conduct of the players on the field. There is nothing in the facts that the respondents have brought before this court that actually, in any case, points to any player or official of Kakyanga Football Club's conduct, act or omission that in any way affected the conduct of the match on the field, which can be correlated with the analytical betting anomaly. Members of the panel, it is the appellant's submission that indeed the respondent does not in any way connect the appellant to the alleged manipulation. Moving on to my third limb of argument, which is in regard to the fact that the facts of this case do not fall within Article 43. Article 43 is the governing law for match manipulation, and it clearly prohibits any act, direct or indirect, that influences the proceeding or conduct of a football match. The respondents have not in any way brought any evidence that shows any conduct, any act or omission of a player of Kakyanga Football Club or any official. They have not shown any action of any of those people who are related to this club that in any way influenced the proceedings or the course of the match against St. Enterprises Limited. Therefore, members of the panel, I pray that this court may find that the appellant's involvement in the match manipulation was not properly satisfied. In conclusion, I pray that the pendulum of justice may swing in favor of the appellant. I will now yield the floor to my co-counsel to submit on issues 3 and 4. Thank you.
Thank you, honorable members of the panel. First of all, I request to the clerk to inform me of the remaining time.
No, you have
have 15 minutes? Thank you very much. Thank you, honorable members of the panel. As earlier introduced by my co-counsel, my name is Maweji Alvin, submitting on issues 3 and 4, and then say the prayers of the appellant. Honorable members of the panel, the appeal before you is an appeal concerning a club that acted diligently, relied on official communications, and then fielded a player that it had every reason to believe was eligible. Yet, as a consequence, it suffered the most adverse sporting consequences. However, as the counsel for the appellant, we are here to demonstrate to you how the club fielded an eligible player and how disproportionate the sanction of forfeiture was. With your permission, honorable members of the panel, I would like to proceed to issues 3. Issue 3 concerns whether Kakyanga FC fielded an eligible player. And it is the appellant's submission that indeed Kakyanga FC fielded an eligible player. The appellant's submission is going to be based on 3 limbs of argument. First of all, the first limb is that the player was eligible pursuant to the match report. Article 25 of the FAS competition rules provides that all games shall be played in accordance with the IFAB laws of the game. This, therefore, it recognizes the international law applicable in this case. Therefore, Law 5 of the IFAB laws of the game stipulates that the referee enforces the rules of the game. Additionally, through this, he keeps records of the match and provides appropriate authorities with the match report. From this, it can be also included that Article 40 of the FIFA Disciplinary Code provides that facts are included in official reports are deemed accurate. Honorable members of the panel, when you look at paragraph 17 of our facts, I beg to follow with me. Paragraph 17 of our facts, it shows that the referee did not indicate the alleged caution in the match report. Although Article 26 Clause 9 provides that a player who accumulates 3 cautions shall be ineligible to play for the next physically played match. However, the respondents in the appeals committee failed to prove the existence of a 3rd caution on the basis that their evidence they produced under paragraph 16 of the facts, they provided screenshots and videos. This evidence was inconsistent with the referee's match report, which is an official document, which is also recognized as a source of lawful evidence under Article 65, Clause 2 of the FAS Ethics and Disciplinary Code. Additionally, this report was not corroborated, whereas corroboration under Article 44, Clause 3 of the CAS Code shows that the panel may, if it sees fit, require all additional evidence to the presented evidence. Therefore, from the first Judicial Council, we did not, the respondents failed to corroborate their evidence with the match report. Having concluded my first limb of argument that the player was eligible pursuant to the match report, I then direct this court to my second limb of argument, which is that the party or our client, Kakyanga FC, did due diligence. Due diligence is recognized under CAS jurisprudence, and it is provided under Article 7 of our FAS competition rules, which stipulates that it is the duty of the clubs to undertake preparations and responsibilities of the teams as required by the FAS rules. This requires that clubs must exercise due diligence. However, when you look at paragraph 13 and 14 of our facts, it shows that our client exercised due diligence, where he went and he logged into the football competition management system to ascertain the status and eligibility of players for the match. All players, not only the alleged player. Additionally, paragraph 14 shows he did not stop there. This is a consequence of the first trial to determine whether the player was eligible. Secondly, under paragraph 14, he went on to reach out to the Zamunda Premier League manager via the email communications. And honorable members of the panel, these email communications are official forms of communication provided under Article 9 of the FAS rules, competition rules. So this was unofficial communication. Additionally, our client went to Zamunda Premier League manager because under paragraph 2 of the facts, FAS delegated the running of the competitions, of the Premier League competitions, to Zamunda Premier League. And it is also the appellant's argument that under Article 4313C, Clause C, that real-time records of the FAS competition department are deemed to be correct records of the FAS competitions department. So in real time, dear honorable members of the panel, the real time when Mpalaka FC claimed or alleged that Mandela Nivag had received a caution, the match report indicated that indeed Mandela Nivag did not have a caution. That is a real-time record, and therefore it is deemed to be the correct record at the time. Having submitted on my second limb of argument, I then proceed to my third limb of argument. Relying on those official communications, the appellant, therefore, rely on the doctrine of legitimate expectation as the third limb of argument. Legitimate expectation is a fundamental principle of sporting administration, whereby once a club relies on the official documents or official communications from the football authorities, they can be stopped. And this was seen in the case of AEK Athens versus SK Slavia versus UEFA, a case award of number 2000 of 1988. Under paragraph 4, where the sole arbitrator stated that where the conduct of one party has led to the legitimate expectation on the part of a second party, the first party, in this case FAS, is stopped from changing its course of action to the detriment of the second party. FAS in this case, we see under paragraph 13 and 14 of the facts that our client did due diligence, and then the emails from the Zamunda Premier League manager, which are official communications, as we see under Article 9 of the FAS competition rules, all proved that Mandela Nivag was eligible. Therefore, under issue 3, it is the appellant's submission that indeed Mandela Nivag was eligible pursuant to the match report, which has a weight under the case Lefkimis vs. Hellenic Football Federation, paragraph 186, where it stated that a caution only is imposed, or the disciplinary sanction of a caution is imposed only if it is included in the match report. For emphasis, I repeat the wording under paragraph 186, that a caution is imposed when it is included in the match report by the referee. And additionally, Article 40 of the FIFA Disciplinary Code gives the referee a power or direct the referee to produce any additional reports. And in this case, we see under paragraph 22 that no additional report was produced. So this shows that they failed to provide evidence of a third caution. Proceeding to issue 4, which concerns whether the sanction was proportionate. It is the appellant's stance.
Counsel?
Yes.
Maybe before you proceed to issue 4, were you aware of league letters that were received? The league letters that the player had physically accumulated these 3 yellow cards?
The 3 cautions?
Yes.
Yes, we were with the 3 cautions.
Mm.
The 3rd caution was not supported by any other evidence, and the caution is imposed when it is put in the match report.
Okay, thank you.
Yes. I beg to proceed to issue 4, honorable members of the panel. Issue 4 concerns whether the sanction of forfeiture was proportionate. Honorable members of the panel, it should be noted that this panel has power to review decisions both in fact and in law. In the case award of Njisane Philip vs. Paso, case award number 6637, they pointed to Article R57 of the CAS Code, where it stated that CAS has the power to review decisions both in fact and in law, and also, therefore, it can challenge and annul the decision on the following grounds. In this case, the ground is disproportionality of the sanction. CAS jurisprudence has provided instances or tests for proportionality of a sanction. In Al-Hiral vs. Asian Football Confederation, CAS award number 4260, it was stated by the panel that sanctions must be proportionate to the violation, and excess sanctions are prohibited. Article 9 of the FAS competition rules where the FAS judicial committee shall take into account all relevant factors of offense, the motive, the offender's assistance, and the degree of offender's guilt. And in such mitigating circumstances, this matter may go below the minimum sanction and decide to hand down alternative sanctions as provided under the code. In Sudan versus FIFA, which the respondents relied on in their written submissions, it should be noted that the facts are distinguishable to this matter. Even though the principle was about eligibility, Sudan case involved an instance where CAF had informed the Football Association about the ineligibility of the player. However, they went on to field the player. In our instance case, Kakyanga FC did due diligence. We were told in good faith, our client was told in good faith, that the player was eligible, and we relied on such official documents. Under paragraph 30, the respondents may use Sudani case. It is definitely under CAS jurisprudence, we see that the historical patterns of warnings also act as mitigating factors, and also there was no bad faith applicable in this case. And this was stated in the CAS award before, where this same panel set a precedence that I pray it should uphold, or it may uphold, where it stated that a club acting on good faith should not be sanctioned beyond its control. Therefore, such an automatic suspension provided under Article 26, Clause 9 should not apply. Reason being, the CAS set a precedent showing that a party that acted in good faith should not be punished beyond what it can bear. Therefore, CAS may recognize other sanctions in case the player is found ineligible under Article 6 of the FAS Ethics and Disciplinary Code, which include warnings, fines, because this sanction of forfeiture was not proportionate. In submission to issue 4, I conclude by saying our client was eligible to play against Mpalaka FC, and the sanction given to it by forfeiture was disproportionate, And our prayer as the appellant is that, first of all, may this panel swing the pendulum of justice by upholding that Kakyanga fielded an eligible player, the sanction was disproportionate, and thirdly, there was no match manipulation. I therefore submit.
I'd like to thank the councils for the appellant, and for the interest of time, we'll immediately go to the respondents.
All right. Just some questions for the appellants. And the first one is, as a club, Kakyanga, do you also keep your own records, or you want to rely fully on the league? Do you have an internal records keeping management?
As a club,
Yes.
we would like to stick to the facts, but it is a duty of a club, of course, we have seen under Article 7, to make sure it fields only eligible players. And of course, I consider that we have records.
So it's your duty to keep your records. You don't need to rely on the league.
Yes.
Okay.
However, those records, I beg to proceed.
The other one, that's
Okay.
enough. Fair enough. You also spoke about corroboration. Is
Yeah.
corroboration a must? Should the respondents corroborate whatever evidence that they present?
It is not a must. It is not a must, and it is at the discretion of the panel under Article R44, Clause 3 of the Code. However, Article 65(2) of the FAS Ethics and Disciplinary Code provides for other relevant sources of evidence, of which the respondents relied only on the screenshots and videos, which were inconsistent with the recognized document, official document, that shows the sanction of players.
All right, fair enough. Then the last question. When you're doing the due diligence, did you also confer with the Football Federation of Zamunda?
With the FAS?
Yes.
When you look at paragraph 22 of the facts, it shows even after the hearing, FAS itself did not have the reports, and it was waiting for the inquiry from ZPL.
No, my question is, before you fielded the player, did you confer with FAS? That's the question.
No, we did not confer with FAS.
All right, thank you. No further questions.
Maybe before we move to the other side, I just have one question. One of your strong points is you're saying that the panel shouldn't rely on just one report. So maybe to enlighten us, why shouldn't we just rely on the information from just one report that was made by?
Yes, thank you, Madam Arbitrator. This is because the match report is conclusive and it is final, as provided under Law 5 of the IFAB laws of the game and Article 40 of the FIFA Disciplinary Code, which provides that facts in official reports are deemed to be conclusive.
All right, thank you. Further questions?
I have a question for the appellant. When you reference, I believe, Club Sportive versus UEFA, and there's a comparison that here it's only one instance where Club Sportive and UEFA was 50. Is it the opinion of the appellants that are you trying to weigh specific matches? In certain cases, should one match supersede 50, or should 50 be a minimum to one? If you could clarify.
Thank you so much, Mr. Arbitrator. First of all, I would like to refer this panel to the case of Bestasis JK versus UEFA, in which case it was stated that the proper standard of proof is the comfortable satisfaction, and that the adjudicatory channel must have a high degree of confidence in the evidence that is adduced. That is the most important thing. The panel must have a high degree of confidence in the evidence. A single match report is not enough. It is simply a mere allegation. It is not enough to build that high degree of confidence in the evidence adduced. And to clarify as to why I use the Skandavu case, it is because I'm not trying to say that one match is not enough, but rather having simply a report from one match cannot prove a very serious allegation like match manipulation. You need to be able to draw a pattern that can clearly link the club to the alleged match manipulation. Thank you.
Thank you very much. If there are no more questions from the panel, we'll hear from the councils of the respondents. Thank you.
Esteemed arbitrators, thank you once again for the opportunity granted to the respondents to make their case. The respondent would like to clarify on the initial preliminary objection in regards to the jurisdiction. It is in regards to the mode of submission that we've been following, in that where the respondents intend to challenge the jurisdiction of this tribunal, they would submit first and delve into the substance of jurisdiction, and then the appellants go on to respond to the challenge of that particular point. But then it's not that I was challenging the jurisdiction of this particular tribunal, but it was in regards to the order that we've been using in the previous rounds, and this time we are not guided by court in terms of the order of submission. And on that ground, since I've got guidance from the tribunal that this tribunal is indeed vested with the jurisdiction to entertain this matter via Article 87 of the First Ethics and Disciplinary Code, I'll go on and submit that even though this tribunal has the prerequisite jurisdiction, core aspects were left out in regards to the way this matter came before. And if you allow me proceed, I would like to persuade this tribunal with the case of Loyal AM Football Club versus South African Football Association, a 2021 decision, CAS Arbitral Award 8403, in which case the arbitral tribunal set up 3 conditions that must be fulfilled in order for CAS to exercise this jurisdiction after finding itself properly vested with it. Number 1 is that the parties must have agreed to the jurisdiction of the CAS. Secondly, that there must be a decision of a federation, association, or a member, or another sports-related body. And lastly, that the internal remedies available to the appellant must have been exhausted. The respondents indeed agree that the second and third conditions are satisfied. There is a final decision of FAS pursuant to paragraph 21 of our fact sheets that shows that there is indeed a final decision rendered by the FAS Appeals Committee, and internal remedies were exhausted pursuant to the same facts under paragraph 21. However, the first and most fundamental condition, consent to CAS jurisdiction, is missing. There can be no arbitration without consent expressed in an arbitration agreement. Under Article R47 of the CAS Code, consent exists only if the parties have concluded a specific arbitration agreement, or if the statutes or regulations of the body expressly contemplate a right of appeal to CAS. Now, as we showed under Article 55 of the First Ethics and Disciplinary Code, decisions rendered by the Appeals Committee in regards to domestic disciplinary disputes that before this court, which was rendered on 24th April 2025, that decision was declared and rendered final and binding with no reference to CAS. And I would like to also persuade this tribunal to adopt the jurisprudence that was taken in the case of Ashley Cole versus Premier League Football Club, a 2005 decision, where CAS refused to exercise the jurisdiction on grounds that there was no express arbitration agreement in regards to CAS exercising jurisdiction. And given the fact that there is no agreement between FAS and its entities in regards to bringing this matter before this tribunal, we ask that beyond the legal position, they consider the policy considerations that might come as a result of exercising jurisdiction, in that they undermine the party autonomy, which is a core principle that even FIFA upholds under Article 14 of its statutes, and it's that party autonomy that protects these bodies in regards to exercising jurisdiction over domestic issues, which have been clearly handled in regards to paragraph 18, paragraph 19, paragraph 20 of the facts that shows that different levels that this decision has gone through. It started from the adjudicatory chamber, it went to the disciplinary panel, and it went to the first appeals committee. And therefore, that shows that indeed there is room for justice in our domestic setting. And more so, we ask this tribunal to that sports integrity works better when there is consent of the parties before CAS. Where a party is dragged into an arbitration, then there is a likelihood that they would not even fulfill the award, and that will undermine both CAS and also create a backlog that is already before this court. For all these reasons, the conditional nature of Article 86.12 that I talked about in our preliminary objection, the clear finality under Article 55, the absence of clear consent, the authoritative guidance of the case I cited of Royal AM Football Club versus South African Football Association, which I request this tribunal to be persuaded with the addition of Ashley Cole versus Football Association Premier League, and the important policy considerations I gave you, we respectfully submit that this panel refuses to exercise its jurisdiction pursuant to Article 186 of the Swiss Private International Law Code Act, which provides for this tribunal to exercise its power to adjudicate on whether it has jurisdiction, and of which it can exercise that power by rendering this particular matter not admissible for lack of jurisdiction. If the tribunal allows me, I will go on and address the first merit of the matter, which is match manipulation. Thank you, arbitrator. So, this case is about whether a club can meet a referee and a betting executive 1 week before a match, deliver exact result of a market heavily bet on, and then claim that it was all coincidence, and whether the lower bodies were wrong to call it manipulation. The lower bodies said no, and we agree that they were right. We submit that there was a clear violation of Article 43 in regards to this aspect of match manipulation. We shall proceed under, the respondents intends to proceed under two heads of argument in arguing the aspect of match manipulation. First, that all ingredients of Article 43 were fulfilled, and secondly, that the evidence rendered and applied by the lower bodies met the standard of comfortable satisfaction under Article 66. Moving on to the first aspect of ingredients of Article 43. Article 43 of the First Ethics and Disciplinary Code prohibits any direct, active or omissive act or omission that influences the course or result of a match for an improper purpose, and this includes betting gain. The lower bodies correctly identified each ingredient on the evidence before them. First, there was an unlawful act or omission. On 16th March 2025, Kakyanga's head coach Alton Civic and player Mandela Nivag engaged with referee Chuck Muguri and Leobet CEO Yuri Zakaria at the award ceremony. That is under paragraph 9 of our fact sheets. They did not just take a picture as the appearance might claim, but they were also seen briefly having a chat with Coach Muguri. This is an unclear, unlawful omission and amounts to indirect conduct that is covered under Article 43. In the case of O versus UEFA, a 2010 decision, CAS Arbitral Award 2172, the panel held that contact between club officials and referees shortly before a match constitutes an unlawful act capable of influencing the result. In that case, the referee who had connived with criminal gangs to influence one match involving UEFA was found to be conniving and engaged in match manipulation, because he even confessed that he was threatened if he revealed the information outside. We asked this tribunal to adopt the reasoning in O versus UEFA to find that the same principles apply and that the lower bodies were right to treat this interaction as the starting point of manipulation. That takes me to the second aspect in regards to the act having influenced the result of the match. On 23rd March 2025, in the match refereed by the same Chuck Mugweri that we interfaced with under 1 week before, Chuck Mugweri awarded 11 yellow cards in a match that the appellants claimed to be highly contested. But we find that 5 yellow cards were awarded to Kakyanga FC and 6 yellow cards were awarded to Sen Enterprises. And the match ended 1-3, exactly as the betting patterns had predicted, in that the match would end by a score of 4 goals. The abnormal disciplinary pattern and precise scoreline clearly indicate the course and result of the match and show how this indeed influenced the match. Lastly, under this aspect of match manipulation, we submit that the influence was indeed for an improper purpose, and that is the betting gain, as the TSIS report reported that there was overwhelming betting evidence. But unlike what the appellants claim that we rely solely on the TSIS report, would like to invite the tribunal to also adopt that and consider paragraph 11 of the fact sheets that shows that the first investigatory chamber went on and conducted an independent investigation that substantiated the findings of the TSIS report. That was the same reasoning that was followed in the case of FK Popenda versus UEFA, a 2009 arbitral award decision number 1920 that was awarded on 15th April 2010, where the panel found manipulation, where there was referee contact combined with suspicious betting patterns on a single match. The facts show that indeed this was a single match that involved the prior contact with the referee and indeed influenced the match and the betting patterns. That takes me to the aspect of comfortable satisfaction, that the appellants said that the respondents did not comfortably satisfy in the lower courts. The lower bodies properly applied the standard of comfortable satisfaction under Article 66 of the First Ethics and Disciplinary Code. This is a heightened civil standard requiring a firm and a binding conviction based on reliable evidence, taking into account the gravity of the allegation. It allows strong circumstantial evidence because match manipulation is clandestine in nature. Clandestine, I mean that you will not get people openly coming out to give evidence against teams because of threats that come from these powerful entities like football clubs. The evidence before the lower bodies was mutually reinforcing and compelling. The pre-match contact with referee and betting CEO under paragraph 9, the abnormal 11 yellow cards and exact 1-3 result given under the highly contested match under paragraph 10 of the facts, and the immediate TSIS report of overwhelming evidence that was not only submitted immediately after the match, but also was immediately corroborated by the independent report given by the first investigatory chamber. Taken together, unlike what the appellants might claim that we rely on one independent report, all this creates a firm conviction that is required by Article 66. We would like to invite this tribunal to adopt the findings and reasoning followed in the case of Igor Labutz versus Football Association of Ireland, a 2018 CAS decision, Arbitral Award 605, on paragraph 65, where the panel upheld the finding of manipulation based on betting anomalies and contextual links, even without direct proof of payment. The panel noted that the combination of suspicious betting patterns and unusual match events can be sufficient to establish liability. This is directly analogous to our case. The appellant argues that the evidence is mere suspicion and that the TSI's report is insufficient. With respect, that understates the cumulative weight of evidence that is before this tribunal. The appellant also relies on the case of FK Povenda relies on the case of FK Povenda, but here a single match in.
So sorry to interject,
Yes.
but given that we have 25 minutes and you have 10 left, we also want your co-counsel to
Yes.
carry on, so that he's not a passenger. We want him to be meaningfully involved.
Yes. Thank you so much. I was concluding the last aspect, and that is that.
So you just cut it there, understandable. Let him just carry on. Since you're a team, you're comfortable, carry on.
Thank you so much for your guidance, Mr. Arbitrator.
Dear members of the panel, thank you for this opportunity. A very good morning to you. My name is Edward Oundo, counsel for the respondents.
Ondo, I'll just request you that you use the podium. Sorry to make you less comfortable than your colleagues, but just to stop that interjection. You can go with the mic.
Dear members of the panel, as I had earlier introduced myself, my name is Edward Oundo, counsel for the respondents, Football Association of Zamunda and Mpalaka County FC. My task here today is to address issues 3 and issue 4. Now, issue 3 deals with the eligibility of Mandela Nivak to participate in the match against Mpalaka County, and issue 4 deals with the proportionality of the match for future sanction. Now, Mr. Arbitrators, dear arbitrators, I will proceed to argue issue 1 under 2 heads of argument. Number 1, that Mandela accumulated the 3 cautions. And secondly, the club is strictly liable for this offense. And then under issue 2, I'll proceed to argue that the sanction meets the threshold of proportionality under Article 9 of the First Ethics and Disciplinary Code. Dear members of this panel, the matter before us today is of a club that fielded an ineligible player and also utilized administrative errors to gain an unfair advantage in the game. Now, the club is also here today, Kakyanga FC is also here today to request this panel to soften the consequences of their actions. However, the respondents are going to show that Mandela Nivak was ineligible to play against Mpalaka County, and secondly, that the match for future sanction was proportionate. Now, proceeding under issue 3, and under my first head of argument that Mandela received the 3 cautions. Dear members of the panel, in this head of argument, my task is very simple. I'm going to guide the panel to the exact places or the exact quotations in the facts where he received the 3 cautions. Firstly, he received a caution against Renzori Heroes, paragraph 6 of the fact sheet. And then just after that, on paragraph 7, he received a caution against in the match against SC Hillside. Then lastly, against CEN Enterprises in paragraph 10, he received his 3rd caution. Now, I'm going to proceed under my second head of argument, which is going to deal with a contestation of the 3rd caution, and which is the major dispute that the appellants are bringing. Firstly, the appellants argue that the 3rd caution is invalid because the caution was not recorded in the match official's report. Secondly, that they relied on multiple confirmations. However, the respondents acknowledge that there were indeed administrative errors on our side, but there are remedies that the law provides. As the appellants had quoted Article 40 of the FIFA Disciplinary Code, we would like to guide this panel. We respectfully disagree with the way the appellants quoted Article 40. They misguided you because they read it in half. They only said that the facts in the match officials' reports are only presumed to be accurate. But this is not all that this article says. It says that they are presumed to be accurate, but can be proven otherwise. Therefore, there can be evidence presented to prove the match officials' reports to be invalid or inaccurate. Now, this brings me to paragraph 16, and noting that the appellants had earlier submitted that, there was no evidence provided by the respondents to prove that Mandela Niva actually received the third caution. I would like to take you to paragraph 16. Screenshots from the appellant's own social media pages highlighting Mandela Nivag's third caution were provided. Secondly, there were also screenshots from the Zamunda Premier League website. And thirdly, there was video evidence. The appellant's submissions that there was no evidence is truly false, according to the fact. Now, the other thing that the appellants seem to overlook is Article 50 of the FAS Ethics and Disciplinary Code. Article 50 of this code emphasizes the field of play doctrine, which the appellants have completely ignored. Now, the field of play doctrine deals with or emphasizes that decisions taken by the referee on the field of play are final. Dear members of the panel, it is not the emails that are final. It is not the other communications that are final. What the law states is simply that the decisions by the referee are final. However, the appellants also overlooked that and went on to proceed that the match reports were they were accurate. However, in regards to also the question that you posed to them, and the panel posed the question asking them if they have a responsibility to track their players. Article 20 of the FAS competition rules provides that they have a responsibility to track. However, we are here today because the appellants failed to do their part. Yes, the association has a part to do. They have a role to play. But we are here today because they failed to track their players. They also considered that they were aware that Mandela Niva received a caution. They went on to argue good faith. Dear members of the panel, when you know that your player has received caution and you can prove the match officials' report inaccurate, and you don't, this is not good faith. This is tactical blindness. It is choosing facts that favor you and leaving the ones that don't favor you out. Now, proceeding to how to strict liability, the respondents submit that the appellants are strictly liable for this offense. I would like to persuade you with the case of Feyenoord versus UEFA, the CAS Award 2007, on paragraph 17.
Mr. Wundo, sorry to drag you back. The argument that you were making on, you said Article 20 of the FAS statutes?
Competition rules.
Competition rules. Just rephrase that argument for me.
Article 20 provides for, Article 20 is large, but it provides for clubs to have a responsibility of tracking their players. Therefore, they should have...
Where exactly in 20? That's what I'm trying to run. Where in 20 is that obligation?
Pardon?
Where in Article 20 do we find that obligation for the clubs to track their player data?
I apologize, I've not carried the exact laws with me.
All right, you may proceed.
Thank you. So, the club is strictly liable for this offense because in Feyenoord versus UEFA, the panel emphasized that a club is strictly liable for its players and their supporters, despite acting with due care or due diligence. Now, proceeding to issue 4, which deals with the match for feature sanction being proportionate. Now, dear members of the panel, the appellants argue that because of legitimate expectation, this match for feature sanction is disproportionate. However, Article 9 of the FAS Ethics and Disciplinary Code provides certain elements that can be relied on to mitigate sanctions. Number 1 being adequacy, secondly being necessity, and thirdly being fairness and integrity. Now, under the element of adequacy, it deals with rectifying the on-field advantage gained by the club during the game. Now, this sanction is adequate because it rectifies that on-field advantage. It overturns the 4-0 win and gives a fair outcome. And secondly, under necessity, which deals with application of a proportionate sanction. I request for 2 minutes to sum up the submission. So necessity deals with application of a proportionate sanction. And lesser sanctions like fines do not apply in this case because they do not rectify the on-field advantage. And in UEFA versus FC Sion, it's a CAS arbitral award of 2011 on page 354. Several players who are ineligible were fielded for a game. And the panel in that case emphasized that the match for feature sanction is a proportionate sanction that cannot be achieved with lesser sanctions like fines. Now, thirdly, under the element of fairness and integrity, like I had earlier submitted, the appellants argue legitimate expectation, they argue good faith. However, there can be no legitimate expectation without good faith. Good faith is a crucial element of legitimate expectation. Now, according to our facts, there is evidence that they received the caution. They did not rely on the evidence. They went on to utilize the administrative errors and did not carry out their responsibility. They ignored the law that mandates that referees on-field decisions are final. This is not good faith. This is, like I had posed before, this is just using the different circumstances to their advantage. This is tactical blindness. Now, I would like to persuade this panel with a case, Legia Wasozo versus UEFA. It's a CAS award of 2014 on page 117, where an ineligible player was given a suspension, and when they fielded this player after the match, the panel in this case overturned that decision and gave and upheld the match for feature sanction. Having submitted on these 2 issues and proven that Mandela Nivag was indeed ineligible to play against Mpalaka County and the match for feature sanction was disproportionate, the panel's responsibility now is to protect the integrity of the competition. If every club utilizes administrative errors, it's going to harm the integrity of the competition and thus distorting the competition. I would like to conclude with the prayers of the respondents. Now, having due regard for the submissions that we've just placed forward.
We'll find your prayers in the submission.
Thank you so much.
Just some questions for you, beginning with Mr. Msoki. On the issue of consent, where you said there was no consent. When you said there is no arbitration agreement, there is no consent. Do your clients, the club, did they agree to the statutes of FAS? Did they? So did your clients are FAS, isn't it? So did they agree to their own statutes?
FAS agreed to its own statutes.
Did the statute, or does the statute provide for arbitration before CAS?
The statutes provides for a conditional arbitration before CAS.
So, using your own statutes, can I or am I right to say that then you consented to your own statutes, thus consenting to arbitration before CAS.
We consented to our own statutes, but the conditional precedent to that particular provision was not fulfilled, in that there is no consent, express consent, and even if there was to be implied consent, the implied consent should be clear, in that it should not be confined within indirect clauses that do not speak to mandatory CAS jurisdiction, as the appearance might want this case to be.
Okay, thank you. The other one is on, you say that the betting patterns, there was a result of the markets show that there will be 4 goals in the game and there are indeed 4 goals. Is it unusual that people, the punters who place bets, get accurate scores? Is it unusual?
It's not unusual, Mr. Arbitrator, but in this case we rely on the predictions and the report that was given by the first investigatory chamber, relying on the independent report that had been submitted under paragraph 11, which showed that there was indeed a prediction that 4 or more goals would be scored, and there were live betting patterns during the game that showed that most of the people placed bets on the 4 goals being scored at the time.
Yes, so, but irrespective, some people can predict, even they can predict who will win the World Cup, even if you're days away from the final, isn't it? So
yes.
It's possible.
It's indeed possible to predict, but then in this case, we are having overwhelming evidence of betting patterns.
Just want to get that. Then are you the one who argued the screenshots, or it's your colleagues? Oh, so you have the mic, yes. So what weight do we attach to the screenshots that are from the social media posts that you referred to? What weight do we attach as a tribunal?
Thank you so much. This weight corroborates the evidence that Mandela and Ivag received the 3rd caution. However, secondly, Article 9 Clause 4 of the Affairs, Ethics and Disciplinary Code states that members of the panel are not subject to mandatory rules of evidence, rules of admissibility of evidence and rule of law, which means such screenshots can be admitted to corroborate evidence that he received the caution.
My question is on weight. Yes, can be mentioned, but what weight do we attach?
In regards to that question, it's corroborative evidence. So it just corroborates that you received the caution.
Okay, fair enough. So, and then the other one, you said that the field of play doctrine, the referee's decision is final. So in these circumstances, are we also correct to imagine that the referee, having made a decision not to record the card, even that was final?
No, that cannot be taken as final, because as humans, there are errors that can be made. For example, one maybe might forget to include. However, when there is evidence that that caution has actually been given, then it's what is final.
So, talking about errors that you've mentioned severally. So because you consider there were errors.
Yes.
So is it fair for us to punish Kakyanga FC for the administrative errors?
Yes, it is, because there is collective responsibility. Our clients have a role to play. However, the club also has a role to play. And neglecting their responsibilities or their role cannot negate that they will not be punished. They have to be punished.
I have just 2 questions. One goes to Gilbert, and then the other goes to you, counsel. So to Gilbert, you cited suspicious betting patterns and socialization as your primary evidence of match manipulation. So do you have any direct evidence that links a special officer or a player of Kakyanga FC to the referee or a known betting syndicate?
Thank you so much, Madam Arbitrator. in regards to the direct involvement that you pose before the respondents, would like to submit that Article 43 of the first Ethics and Disciplinary Code includes, under match manipulation, includes indirect or direct actions. The involvement of the referee in this betting partner and the direct engagement that we see under paragraph 8 of the fact sheets, where players of Kakyanga FC are seen having a brief chat with Chuck Mugweri. That shows the direct evidence that we corroborated with the other aspects that we showed under paragraph 10 involving the highly contested match that involved 11 yellow cards and the exact 1-3 loss goal difference. And also paragraph 17 shows that Chuck Mugweri, the same referee who was seen having a brief chat with one of the players, goes on and omits recording the caution of yellow card against Kakyanga's player Nivang. And all that goes on to show the pre-match engagements and the post-match engagements when corroborated with the match statistics and activities that went on during the game. They all go on and show the manipulation aspect that the respondents claim. And we submit that Article 43.2 applies the aspect of strict liability against clubs. So it is immaterial whether the clubs were directly involved, as long as there is an indirect involvement of some of the players, including as we have seen under paragraph 8 of the facts, with that player chat with the referee. It goes on to show that indeed this Kakyanga FC club should be found strictly liable for match manipulation.
All right, thank you. And then to you, Edward, it is a matter of record that the league management issued an official written clearance stating that Mandela Nivag was cleared to play. That is a matter of fact before us. So my question is, are you arguing that the club cannot legally rely on the official respondents sent by your own administrative officer?
No, that is not what we are arguing. In regards to how the law has put it out, for example, like I had earlier stated, Article 40 of the FIFA Disciplinary Code, which provides that match officials' reports can be inaccurate, which means that, yes, there are administrative errors, but they have also been provided, remedies have been provided under the law that they can be proven otherwise. For example, if there is information that the association has put out that is false or that is presumed to be correct, if clubs are actively doing their job, they can also either prove inaccurate or prove accurate the information that has given to them. So in a way, this is negligence on the side of the club.
If I may ask a follow-up question to my colleague arbitrator, if we go to paragraph 15 of the facts, which states that Mpalaka County FC filed a petition alleging that Kakyanga FC had fielded an ineligible player. And the counsel for the respondent, went ahead and said the appellants are utilizing administrative errors. My question to counsel is, if Mpalaka themselves also went on the website and didn't see anything and didn't file a petition, what's the opinion of the respondent? Are you not abdicating your role to the clubs? And again, now you're requiring a club to act in good faith, but in sporting circumstances, if they can get an advantage, is that you now saying no one is allowed to get any advantage based on the errors of the administrator?
I beg that you maybe reiterate that question.
Yes. If Mpalaka FC never filed the petition, so Kakyanga know the cards they have, there's no update on from the respondent and Mpalaka in this case does not file a petition, is it the opinion of council that it's still not the fault of FAS? If no, I hope if you may help me.
Yes, so if I could inverse the question, is that if nothing happened, if we weren't here, would we stay with that error on the record, so to say? Is that no one complained, the error was made, so would we stay with the error on the record, and how do you deal with that error then, if no one raised an alarm that there was an error?
If no one had raised an alarm, I find it a bit difficult to say that no one would raise an alarm given the circumstances of the fact, because Mandela Nivag received the caution, and not only did he receive the caution, but there was evidence. Though we are not saying this is the best evidence, but we have videos, we have screenshots. So definitely an alarm is inevitable. However, if Mpalaka County hadn't raised the alarm, it is a possibility, yes, that they would not, the error would still be on record, basically.
All right, thank you. So I think we'll go back to the appellants. Your 5 minutes, but only limited to the issues that have been raised by the respondents, so don't import any other. And after that, the same will apply to the respondents.
Thank you very much, honorable members of the panel. In response to the counsel for the respondent, in regards to eligibility, he quoted paragraph 6 of the facts, paragraph 7, 2 instances where our client received cautions. However, the one of Sen Enterprises was not included in the report, and they also admit that it was an administrative error. The counsel for the respondent still quoted Article 40 of the FIFA Disciplinary Code, and he said that we misquoted it. I would like to guide this panel that we did not misquote Article 40 of the FIFA Disciplinary Code. We quoted it in its entirety by saying facts contained in the official reports are presumed accurate unless proven otherwise. And I went further to show that they failed to prove otherwise by stating that their proof was inconsistent with the match report, which you see as a final document. Secondly, they did not corroborate their evidence that they presented, which is a requirement under Article R44(3) of the CAS Code. Additionally, counsel for the respondent cited Article 20 of the FAS competition rules, where he was misguiding court on the responsibility of the player, of the club, to field eligible players. I would like to guide this court back on track that this responsibility is embedded in Article 7, Clause 1, Subclause C, where Kakyanga FC exercised due diligence by relying on the stipulated systems. Secondly, the official communications by the Zamunda Premier League manager. The counsel for respondent again quoted UEFA vs. SCZion, whereas the case has different facts, although the same principle. SCZion involved a player that was banned, and he did not consult the authority to field that player. In this case, the difference is that we went on, our client went on to consult the league manager, which found that the player was eligible. Secondly, counsel for respondent cited Legia Waswaza case, where still the facts of the case are distinguishable in this case. This case before this honorable panel stands alone. The case in Legia Waswaza involved a player who had been fielded while the ineligibility period had not yet been concluded. The eligibility period of the player was still going on, whereas the team fielded the player. So if I was before justice, I would ask a question that if we cannot rely on the association official communication, then how can we trust the Zamunda Premier League officials who prepare the league? That was if I was standing before justice. Thank you, honorable members of the panel.
Thank you, honorable members of the panel. My first limb in my rebuttal is the fact that the respondent in this case did state that they did consent to the rules of the Football Association of Zamunda, which they do represent. And yet, he keeps on implying that there is no express consent in their own laws to provide for the jurisdiction of this case. And he keeps on implying or basing that fact on Article 86, Clause 12 of the FAS Ethics and Disciplinary Code, which clearly stipulates that parties not satisfied with the decisions of the FAS Appeals Committee may seek redress with the Court of Arbitration for Sport. Therefore, there is an express provision under the rules of Zamunda that indeed an appeal can be brought before this court. And two, the respondent actually manufactured facts unless they allege that they do have other facts which they were not provided with. And paragraph 8, where they did say that there was first of all a hug, that's not there. And two, they stated that this was a private ceremony, yet it was very public. Very many sports personalities were in that place. This was not a discreet meeting between Kakyanga Football Club and any suspicious individuals. And actually, the respondent, based on the case of O versus UEFA, honorable members of the panel, I beg for a minute to complete my rebuttal. Thank you. The respondent stated that, using the case of O versus UEFA, that indeed meeting a referee who connives with suspicious authorities, in this case criminal gangs, would amount to suspicious activity. Now, unless the respondent has other facts which are not given to the appellant, there is nothing in the facts that stipulates that Chuck Mugweri was involved in any suspicious activity. He was simply a person at an award ceremony who had a brief chat with Kakyanga football players. Thank you.
Thank you for your submissions. Council, please let's continue.
Thank you so much for your guidance, Mr. Arbitrator. In response to the first point raised in regards to our reliance on the conditional clause under 86.12, the appellants indeed take a stubborn route of reading the statutes in half without considering the conditions that are there. The cited article under 86.12 has a condition that provided that the procedures in this particular code, in this particular statute are followed, then CAS can have jurisdiction. And we reiterated that certain procedural aspects involving the signing of the independent arbitration agreement were not fulfilled. And agreeing to the fact that we signed the first rules and ethics code of conduct does not mean that we agreed to arbitration. Arbitration is a sophisticated entity that requires careful scrutiny without adopting the entire regulation to imply that we agreed to CAS's jurisdiction. On the aspect of the case cited of O versus UEFA, we cited it in order to adopt the reasoning that was followed in order to consider the issue of whether circumstantial evidence could establish match manipulation to the standard of comfortable satisfaction. And in that case, the panel upheld the finding of manipulation against the referee because he was involved in direct engagements, just like in the facts the referee, Chuck Mugweri, is seen to have direct engagement with some of the players. Thank you.
Thank you for this opportunity. I would like to briefly respond to the appellant's argument. Now, I find that the appellants are indecisive on whether Article 40 was half
read or it was read in full, because we submitted that facts of the match officials' reports are presumed to be accurate but can be proven otherwise. However, the appellants have come back and reiterated that same argument that we made, but then said that we misconstrued this article and that we misguided the panel. This is very confusing, and I believe that they should make up their mind and read Article 40 in full, guide the panel in full. Secondly, they quoted that we misapplied UEFA versus FC Sion. However, the facts of this case were similar, unlike to what the appellant submitted. It was all dealing with a match of feature sanction, dealing with fielding ineligible players. There were ineligible players fielded, and the match for feature sanction was upheld, and it was declared proportionate. Thirdly, the appellants seem to run away, or they seem to evade the fact that they cannot only rely on first sources. Now, in Sudan Football Association versus FIFA, case number of 2012, it was of 2012, 3013, paragraph 48 states, and in verbatim, the suspension of a player is automatically imposed if a player is expelled from a match. And secondly, suspension has immediate effect and it's not dependent on confirmations. So they neglect this responsibility, they evade this responsibility, and this is exactly why we had submitted earlier, that they are utilizing these administrative errors. Thank you.
Thank you very much, Counsel of the Respondents. Thank you to the counsels of both the appellant and the respondents. If you may, we would like to go as the tribunal and confer, unless there's anything else. Thank you. If we may, thank you very much. This session of the Court of Arbitration for Sports is on recess until the tribunal gets back. Thank you very much.
Thank you very much, ladies and gentlemen. We definitely deserve a round of applause. You could literally hear a pin fall in this room. The level of concentration was so up there. Mr. Bainman, you're happy? Wonderful, wonderful. The professor over there has nodded. Mr. Otuchet here, Simon Peter Komake, Musali was telling me I must attend to the football federations. These are things that concern you. Ladies and gentlemen, let us allow our arbitrators to kindly take leave. We will kindly take the space we had, the briefing. Please, a round of applause to the arbitrators. Let us put our hands together for the appellants from Cavendish University, Jovia Navala and Maweji Alvin. Ladies and gentlemen, in the same spirit, put your hands together for the respondents from Makerere University, Mosoke Gilbert and Owundo Edward. Wonderful, wonderful. And of course, the clerk of the court, Lori Gochalia. Now, kindly, our participants, you may take your seats, kindly. Find where to sit and wait for the decision. Was the malaria time malaria-ing? Did it? Wonderful. Now, the judges are taking a moment to evaluate this session. The criteria is as follows. The participants will be judged in criteria 1 on the structure and clarity of legal arguments. Structure and clarity of legal arguments. The second is the knowledge and application of the law. Article 40. Yes, Article 40, Article 43, Clause 12, Article 86 of FAS this. You must be knowing those things. They will also be evaluated on the use relevant cases or versus UEFA. For those that are interested in reading about match manipulation, locus classicus, or versus UEFA, kindly find time and read that one therein. And one of the cases that is very specific to this kind of situation is the South Sudan versus FIFA. Yes, that one also with regard to eligibility of players. So the participants will be evaluated on the use of relevant case, knowledge and use of facts. Paragraph 13, line 2, word 8. You heard those things, right? And you could quickly see the arbitrators flipping. Paragraph 13. Is that where the matter you're talking about is? They will be evaluated on that. Criteria 2, the advocacy skills. The advocacy skills. We have seen what the participants were able to put before us. Response to panel questions. How quickly can you have an answer off your feet? Those that have mooted before know what exactly that can be. You get asked a question and you clearly have no idea. And I must tell you one funny thing. To drive around it and buy some 10 seconds, this is a classic response. May I please seek clarification of your question? You actually had it the first time. Yes, you actually had it the first time, but you are buying time in your head to find a case somewhere in the drawer you kept in your head in, a paragraph that you probably, and those are the tricks to help with this kind of situations. Courtroom etiquette. Indeed, our participants were counsel in a proper court and they treated themselves as such. Time management. Well, I think they will all get top scores in this because we allowed them to enjoy and express themselves through this particular session. That is how they will be scored on a score of all of this adding up to 100. I hope that guides. So while the judges are, arbitrators are busy doing this, kindly take off some time and find a drink at the corner over there. Then we shall converge to give away these prizes in a very short time. Thank you very much. Ladies and gentlemen, malaria time. Malaria time. Now, we'll be proceeding to the award ceremony, but once again, let us put our hands together for the participants and the arbitrators. It's been such a wonderful experience. I'd want to believe it's been the same for me, and I want to believe it has been the same for you, right? Wonderful. So lovely, so lovely. Now, you have listened to the facts of the case, but I would like to invite the CEO of the Star Times Uganda Premier League to give us a brief on what exactly and how important sitting here to listen to this very matter has been, considering the fact that it was a real-time case in Uganda. And if you took notice, the name Mandela Nivag, you had that name? You had it quite well? The actual player is called Gavin Chizito. So Gavin, the other way around is Nivag.
How many minutes, because it is everybody was being timed. How many minutes are you giving me?
You can keep it as not so long as how much African teams can hold a lead in the World Cup, but so quick as how Argentina can recover 3 goals to goals.
Okay, thank you very much. My name is Bernard Bainaman Bampire, otherwise called Triple B. I'm the CEO, Star Times Uganda Premier League. First of all, I thank the organizers of this event, or Moot. What does Moot mean? Moot.
Fantastic.
Thank you very much. A moot in simple terms is a replica of a court session for students. So they exhibit the knowledge, applicable knowledge, which they've acquired in class on a hypothetical case, which has more like realistic facts. So in this case, we had facts of a football player who went for awards and was seen speaking with a betting company, staff.
I get it. Okay. I get it. Thank you very much. I like learning. So the word moot was disturbing me. So thank you for clarifying. So I was thanking the organizers of this event, our panelists, my friends from Cavendish, the parents, and the response. At one point, whoever was submitting, I said, this one is right. Then when the other one comes, I say, now this one is more right. So as we are waiting for the what? For the final ruling, in football we have draws. Maybe I would say I may bet a draw, but in law there is no draw. There will always be a winner and a loser. Having said that, I would like to confirm that this simulated case indeed happened in our league, I think last season but one. And the same arguments you were hearing from both sides and questions from the panelists, those were the real questions. There was a public debate, if not global. There was a debate. Up to now, the debate is still there. During the tea break there, or soda break, or water break, we were having a conversation. Era, it was the same discussion. So up to now, nobody knows. We are waiting for our honorable panelists to tell us. This is a case that happened, a situation that happened. Because I'm conflicted, I will not go into its details. We shall wait for what? But to summarize, in that case, one will be interested in knowing where did it end. The club, of course, took its share of the blame or sanction. The league also had its blame, and the person who was responsible was also sanctioned, and also the referee was sanctioned. At FIFA, I don't know how it concluded or if at all it went there, but they are here. They are going to tell us, the ones of CAS. So, with those few remarks, finally, I thank this audience also. Otherwise, would have had this side without this side. And finally, I thank the organizers for inviting me to attend here. I have enjoyed from the start to the end. Thank you very much.
Thank you very much. Triple B, as we know him, he has been in charge of Football League for a very long time. Ladies and gentlemen, of course, we realize there's accompanying music to this session. I'd like to quickly invite the founder of Mashariki Sports and Entertainment Advisory, Mr. Fidel Mugara Otafire, to give us a word on how important this kind of initiative is with regard to sports law and its growth in the country.
Good morning, ladies and gentlemen. As I've been introduced, I'm Fidel Otafire, one of the founders and directors of Mashariki Sports and Entertainment Advisory. I also serve with Timothy on Young Africa Leaders in Sports as General Secretary. And I want to take this opportunity to thank you for participating. It's one thing to have an idea, it's another thing to have a partner to execute it with. So I want to thank the students, the universities, the federations. I want to thank the organizer for an incredible job. I'd like to thank the arbitrators. I've thanked faculty also. Thank you very much. I'm here to just briefly speak on the why. Why a national sports arbitration? Why a moot? What are the end goals? What are we trying to pursue? In simple terms, we're trying to pursue sports law education, particularly with this moot. Sports law education. It's pointless to have an act, to sign the act into law when we don't know what the act says or how to apply the act. Why this is particularly important in this sector is the European Commission have a term they give that is called specificity of sport. Specificity of sport, that in certain cases, particularly legal, sports has specific characteristics that cannot be duplicated in court. An example is if someone here decides to bite another, that's an assault. Yes, we can agree on that. And the courts would give you a charge or a penalty in accordance with the law of an assault. But what happens when Suarez bites someone on a football pitch? It's still an assault, yes? But the specificity of sports dictates that the law must punish or hear the case in accordance with the law. You cannot give a footballer who can only play until the age of 30 a 30-year sentence. You have killed the man. Similarly is, for example, if we start throwing punches here, they'll call us mad outside. However, if we throw punches and we have signed a contract saying we're boxing and the winner gets a belt, that's not an assault. So one of our main pillars, our main objectives, both as YALS and Mashariki, is educating on sports law. Let's not have... Yes, the courts are there, but the courts can apply sports law through the Arbitration Act. Let's not burden courts with sports matters that are best understood by sports people, yes? There is a cantankerous man in Uganda who once said, leave issues of generals to generals. I think it's also fair if we say we leave issues of sports to sports. People who understand the circumstances, lest we're just surrendering decisions to people who don't know much, or at least know some, but not the specific aspects of sport. If you're debating and you're in court for someone's contract of 4 years, you can't be in court for 2. Does the man stay at home and, wait and who pays, who does what? That's why we're pushing arbitration, we're pushing it through the Sports Act. Handle sports matters very quickly. Another example I can give is, I think we all know how to cook, but we don't know how to cook all the cuisines. We all have driving permits, we all can't drive buses, trucks, lorries. So yes, even if you can drive, even if you can cook, even if you know law, let's make a conscious effort to push it that the people who know sports law are doing sports law issues. Otherwise, we're just going to waste money by sitting here in Uganda and then CAS later overturns it. So if I could leave with a final message from behalf of Mashariki and on behalf of Young Africa Leaders in Sports is please, let's all join hands, let's advocate for a fair sports act, a good sports act. And let's also now push for sports representation where sports requires to be represented. Thank you very much.
Thank you very much, Mr. Fidel Otafire, for those remarks on behalf of Mashariki Sports and Entertainment Advisory. He spoke about the Sports Act, National Council of Sports, and its implementation. Ladies and gentlemen, please, let's welcome Madam Leslie Lakay on behalf of the National Council of Sports, who also has served as an arbitrator in this particular final. Section 55 to 58 talks about sports dispute resolution.
Ladies and gentlemen, good afternoon. I have a grin on my face, and I'm sure you're wondering why. But it brings me great joy and pleasure to sit in such rooms, to take part in such heated arguments. Why? Because we realize that while the law is here, we need knowledge of the law. We need practice of the law. Let the law not just stop at National Council. Let it not stop in our books, but we want it to be practiced. That is why today I feel a lot of joy that we are part of such a trailblazing exercise, one of its kind and many to come. So from National Council, I want to start with thanking you. Thank you to whoever has organized this event. Thank you to whoever is behind all such trailblazing exercises, empowering youth, giving them knowledge, and letting them perform here, both as lawyers and also as arbitrators. So we thank you so very much. And from National Council of Sports, I bring greetings from our head, Dr. Ogwell Patrick, who sends me here to greet you all and to say that he is here with you in spirit, even though he wasn't able to physically be here. So I'm not going to say so much because I took part in the exercise, but I want to challenge whoever is organizing such events. Please make sure that they continue. Us as Ugandans, we benefit. We benefit both as students, who are the growing people of Uganda, and also federations benefit from such exercises. So don't tire, and I encourage you that for us as National Council, this is an initiative that we can rally behind. So don't tire, and please, I give you a challenge. Let this continue. And thank you very much.
Sure, thank you very much, Ms. Leslie Lakay from the National Council of Sports. Today is a Friday, right? On Monday, proposal is on your desk. Proposal is on your desk on Monday. Ladies and gentlemen, you may have read the documents that were shared to you earlier, but quickly, this process started around November, October. They're in with 12 universities. Those universities, including Bishop Stewart University, Cavendish University of Uganda, Gulu University. If you're in here, kindly ask that you stand up. International University of East Africa, Islamic University in Uganda, both the females campus and Kampala campus, Kabale University, Kampala International University, kindly Dana stand up for participating in the NASAM. For the ladies in this room, kindly be mindful that you are needed in sports arbitration. She has done the football law annual Moot. Last year, we did that one together. We have done the sports law annual Moot as well. And now you also did NASAM. Then I think next week you're contesting in the football law annual Moot. So, yes, very important as to why she is here. King Caesar University also took part. Makerere University, ladies and gentlemen, Makerere University. Metropolitan International University. Nkumba University, Uganda Pentecostal University, Kampala campus, as well as Victoria University. All those are the universities that took part in the inaugural National Sports Arbitration Moot. Our arbitrators, we had a list of arbitrators through this process. And I'll start with some of those that are here. Fidel Otafire from Uganda, Timothy Kaja from Uganda, Leslie Lakay from Uganda, Philip Munabi from Uganda, Brian Kajubi, Uganda, Kevin Aijuka from Fufa, Ugandan, Shiba Ampeire, Uganda, Pauline Mbamza. For those of you that have been before Pauline Mbamza, you know the marks don't come in plenty. I have faced her before, by the way, in an anti-doping moot. We had Robert Okot from Uganda. Thank you very much, Cricket Uganda, for sharing with us, Councillor Robert Okot. Davis Karashani from Uganda. Then we also picked a few arbitrators from across the continent. Pius Nduboku from Nigeria. Harian Noor from Kenya. Caroline Mwanzia from Kenya. Raphael Okochil from Kenya. Peter Mwishikilwa from Tanzania. And this one is actually a CAS arbitrator in Switzerland. We also had Judith Zebedayo from Tanzania. We had partners also, Ngoro Mutebi Advocates, the Federation of Uganda Football Associations, FUFA, Max Advocates, Matrix Advocates, Diadem Advocates, Sports Legal Kenya, PCN Sportiva, LP Nigeria. We also had Anshur Ramesh from Corsia de Angelis Association in Italy. For those that were there in the beginning sessions, he took you through the processes of mooting as well as Pauline Mbanza. Ladies and gentlemen, it's been some piece of work for us, I must say. It has been some piece of work. But now, malaria time. We move on. I have mentioned the universities. On Wednesday, we had the semi-finals that had International University of East Africa, Kabale University, Cavendish University, and Makerere University. It is from those that we now have had a final between Cavendish University and Makerere University. Do we have a representative from Kabale University? No. Do we have a representative from International University of East Africa? No. Nonetheless, they have their medals and certificates over there. We shall deliver those later. Now, I would like to invite Mr. Simon Peter Komakech from Modern Pentathlon, kindly. Before you actually do anything, what is Modern Pentathlon?
Thank you, Mr. Moderator, and thank you, panelists. Modern Pentathlon is a sport of 5 games. Penta means 5. We have swimming, running, shooting. We also have obstacle, because it used to be horse riding, but now they brought the Ninja Warrior setup where you run and jump over hurdles and then you claim the victory. It's a very interesting sport. It takes place within 90 minutes. So one athlete, you compete in all those facets of the sport. So it is very interesting. We have been in Uganda now for 9 years. And I'm the president. My secretary is Colin Semanda. And then we are still in the process, as per the Neo Sports Act, being recognized or gazetted as a national sport. But we have won some medals, and we have done so many internationals also. This is all I can say about the sport. Thank you.
Thank you very much, Mr. Simon Peter Komakech, who will be giving away the award for the best overall memorial. Ladies and gentlemen, the best overall memorial. And I'll ask you to pick and make mention of the details in that envelope.
The certificate of achievement for the best memorial goes to Makerere University.
Makerere University gets the award for the best overall memorial. They also get a cash prize.
Thank you.
They also get a cash prize of 150,000 Uganda shillings.
Do they have to view it? just to confirm that we are not giving an empty envelope. There is something here. Thank you.
Thank you very much. Thank you very much. You may stay for a photo, please, briefly. Congratulations to Makerere University for taking the award for the best memorial. Wonderful. I would like now to invite the president of Athletics Uganda, Pastor Otuchet Dominic. And briefly, how many medals are coming from the Commonwealth Games this time around?
Good afternoon, ladies and gentlemen. I've been introduced severally. Dominic Otuchet by name, President of Uganda Athletics. And I lead a federation which is so big. And even going to Glasgow, Commonwealth Games, taking a team of 17 athletes. I think it's the biggest. So we still know that Uganda will win medals through athletics. The big two boys are not there, Joshua Cheptegei and Kiplimo Jacob. They hold 4 world records. Today, I will not say the exact number of medals, but I want to assure you that we shall win all colors of medals. Gold, silver, and bronze in Glasgow. Thank you.
Thank you very much. All colors of medals. The rainbow has 7 colors. Nonetheless, gold, silver, or bronze, whichever it may be, we expect. Ladies and gentlemen, the best oralist in the inaugural National Sports Arbitration Moot. Kindly do the honors, Mr. Otuchet.
I'm reading what is here. Certificate of Achievement. These certificates are awarded to Nabagala Jovian and
congratulations to Nabagala Jovia.
And well deserved. Well deserved. Congratulations.
The best oralist.
She impressed me too.
So the arbitrators are spot on.
They are spot on.
Wonderful. So and she takes a prize, a cash prize of, it's okay, 100,000 Uganda shillings.
Congratulations. This is your prize. Congratulations.
Congratulations to Jovia Nabagala.
Uganda is very proud of you. I'm proud of you too. God bless you.
Wonderful. Thank you very much. Now, before we go into announcing the winner, I would like to invite the president of the panel today to run us through. I may have run you through the criteria, but they did the scoring. They did the scoring. Let the word of confidence come from them.
Good morning once again. Thank you again, Leon. One of the most important things the panel wishes to put across is this isn't like a decision, a legal decision when the results come. We don't want emails saying we're stupid, we don't know the law. No. The organizers have given us a very strict scoring criteria to follow, and that's what we based it on. Structure and clarity of legal arguments. How do you flow with your argument? Are you jumping between bodies? Are you skipping between arguments? Are you making the arbitrators go back and forth in their pages, or is there a flow? Is it logical? That's how we're putting that, and that was out of 15. knowledge and application of the law, I think that that's obvious. You can't start quoting us land cases or company law cases when I'm discussing sports law. And for this one, we must commend both participants that they exhibited very, very brilliant knowledge of the law and they applied it very well. Then there was use of relevant case law. I think there are many law students here. Sometimes people want to just throw as many cases as they find when they don't flow with the argument or there's no, you're showing us you have read, but you're not showing us what you have read, if that makes sense. So we took particular care in when were certain cases used, how many cases were used, how were they applied, and especially in the rebuttal, were they showing willingness to, adjust their interpretation of their own case law they have shared. Then use knowledge and use of facts, again, straightforward. We thank the participants for not making up too many things, for not coming and saying, I've already won 500 cases in cars, so, you kept to the facts. That we also scored. Advocacy skill, I think that was very important to us considering we're in a moot. How well do you carry yourselves as advocates? It's a moot, but we were simulating real life circumstances. Response to panel questions. I think I'll personally apologize on behalf of the panel. I think some questions were Supreme Court level, but both sides responded very well, very confidently. There was no hesitation in what they had said before. When critiqued, they kept what they were saying. That we appreciated. Courtroom etiquette. There's no blood, so I think that went well. And finally, it was time management. How do
and Section 51, 52, 53, which establishes the National Anti-Doping Organization. And indeed, what has transpired today, my honorable panelists, I think I reflect on it and say there are sections in the WADA code which talks about how we manage results, test results for doping, and that sometimes they can be disputed. And if it is disputed, how do we go about either proving that the athlete indeed doped or the athlete is innocent? And I am sure that what you've transpired today is exactly what I would imagine we will be involved in once we begin to ensure that results are managed properly. So I want to thank the organization and the panelists, but also particularly the appellant and the correspondent team. So I want to concur with my colleague that we were weighing who is speaking the truth, who is speaking the truth. So eventually, in my view, they did exceedingly well. As young lawyers in the making, we are confident that this country is building a class of lawyers that begin to appreciate what is in the law from today. And indeed, as you said, sport is specific. There are certain specificities that must be followed. So the lawyer must understand it. And so I appreciate it. And I want to thank the organization very well. I want to thank the participation of the young lawyers. And I have heard of you quoting somebody who said, leave matters of general to general. And I remember that the name of the person who said that one. So I'm not too sure whether... But ladies and gentlemen, I thank you. Thank you so much.
Sure. Thank you very much, Professor. Wonderful. Yeah, that we can do a moot to discover if there's any similarity. Ladies and gentlemen, we now come to the big announcement. We'll announce, Professor will read the winner. Then we'll ask the team, the second team, to come forward and receive their award for second place. All right? I think that does us very good for the afternoon. Ladies and gentlemen, I would also like to invite Mr. Triple B. Baineman, kindly come over. Wonderful, wonderful, wonderful. To announce the winner of the inaugural round of the National Sports Arbitration Moot. Ladies and gentlemen, put your hands together for Professor Celestino Obua.
Ladies and gentlemen, let me read verbatim what is here. Certificate of Achievement. This certificate is awarded to Cavendish University. As winners of the inaugural edition of the National Sports Arbitration Moot 2025-2026, awarded this 10th day of July 2026. A groundbreaking
Thank you very much. Thank you very much. Ladies and gentlemen, Makerere University, kindly come and pick your certificate for second place, your trophy, your medals, and your cash prize. Congratulations to Makerere University. The scores as submitted by the arbitrators, a total score for the appellants of 273 and a total score of 248 for the respondents, as sent by the arbitrators. Makerere University, ladies and gentlemen, let's put our hands together for Mr. Gilbert Musoke and Edward Owundo, who received their certificate for the runners-up sport. They each will receive a medal. A trophy as well, and a cash prize of 350,000 Uganda shillings. Congratulations to Makerere University for second place in the inaugural National Sports Arbitration Moot. Ladies and gentlemen, to the winners, put your hands together for Jovia Nabagala and Maweje Alvin from Cavendish University. And their coach, Mr. Godfrey Ayeranga. They each will receive a winner's medal. Their winner's trophy. And a cash prize of 500,000 Uganda shillings. Congratulations to Cavendish University. Do you want to count the money? Please check. Thank you very much, Professor, for that. We would like to invite all our participants, arbitrators as well. Professor, kindly stay, Mr. Bainemai, just as well join in. Makerere University, Owundo and Musoke, please come forward for a group photo. And as they do that, ladies and gentlemen, I would like to thank you all for being part of this final. It's been wonderful having you here today. We look forward to many more engagements with you and participation in this inaugural kind of competition. Wonderful session it has been. I believe you have just as much learned a million things about sports arbitration. To the sports federations, kindly knock at our doors. We are available to offer judicial guidance. Please, our addresses are available. We have Pauline Mbanza here. I am available. Council are up there. The students too are budding council. Yes, so make use of their knowledge with regard to sports arbitration. Professor, we look forward to the engagement. Anti-doping will be our next point of discussion. Go and do your homework. Go and do your homework with regard to anti-doping. It was a pleasure having all of you. You can, for the photos, you may kindly proceed and have them maybe outside, maybe elsewhere. It was a pleasure having all of you and our arbitrators as well, Mr. Timothy Kaja, Leslie Lake, and Fidel Otafire Mugara. Thank you very much. From the federations, the students, press, and everybody else. It was a pleasure having you all here, and a successful conclusion of the inaugural National Sports Arbitration Moot. Till we meet again.